everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about a topic that is so important to me. It's the question of choosing the right jurisdiction for your divorce. And the reason why this topic is so interesting to me is that a lot of my clients are faced with these questions because they come from an international context. Either they're from two different countries, or they've moved around a lot, or they're just not living in their home country. And one of the first decisions they need to make when they're deciding to divorce is which jurisdiction to choose. And it's a big decision, and it's a decision that often makes people very anxious because they don't fully understand the implications. So today we're going to dive deeper into that specific topic, and Lucy Greenwood is here to discuss with us what exactly people need to consider in making that decision, and she's going to share her tips and tricks around them. Lucy's a partner at the International Family Law Group, and she specializes exclusively in family law, and she advises on all aspects of family or relationship breakdown. Her work often comprises advising international families in England or abroad who have some kind of tie to England through residence or birth. Lucy, thank you so much for joining us.
Hi, nice to be here. Thanks for inviting me.
So Lucy, let's start with the most obvious question, which is, when do couples have a choice with regards to the jurisdiction they divorce in?
Well, in essence, you have to have some connection with the country, and it's a common question that we are asked, and it's often the first question people ask, which shows a certain amount of knowledge, at least, that there are disparities between countries and the laws that they apply on divorce and separation. You have to have some kind of connection with the country you're going to start divorce proceedings with, so you can't just pick a country or say, oh, can you tell me the best one in the world, which I do sometimes get asked, and I say, well, do you have any connection with that country? And if you don't, then it's not going to happen. So primarily, the main connections need to be either party, and it's important to consider both parties because the other person might be doing the same inquiry. And you have to decide whether you've got nationality from another country or a connection via residence with a country. And those are the primary reasons that give you sufficient status, as it were, to inquire whether you can bring proceedings in that jurisdiction. Sometimes there are also countries where people simply can't get divorced, and the Philippines is one of those. And the other scenario where that sometimes arises, although thankfully it's changing around the world, is where you have a same-sex marriage or partnership, formal partnership, and you want to dissolve that partnership or divorce, and that country won't do it. So if there is nowhere else in the world that will do it, then England has an inherent jurisdiction to sometimes assist those people, which is quite an important point for people to be aware of. So you then wouldn't have to have the residential or national or citizenship type connection, but that's unusual.
That's great. So without any connection to England, if people can't get a divorce in their home country, they can come and get divorced here.
Yeah, thankfully they're not that common, but there are scenarios where people simply can't get divorced, and England is fairly receptive and quite a helpful jurisdiction in many ways for people in those sorts of predicaments. And yeah, so I think commonly the most important things in relation to determining whether or not you have a connection is firstly to think about, where you're living, how long you've been living there, and where you were both born, and then communicating with a lawyer in any of those countries that you are talking about. So if, for example, you had a French and English scenario, then the situation would require input from a French lawyer and an English lawyer to determine which jurisdiction might be better for you, and if there's any reasons why you wouldn't be able to bring divorce proceedings in those countries, perhaps because you haven't lived there recently or certain other criteria that a particular country has. We can never know what anomaly there might be with the other country, and sometimes it's quite surprising what can defeat your ability to bring proceedings in that country. So it is incredibly important to get advice very early in relation to that point. So if that is your first question, you're already on it, and that's a very, very important step to take.
Right. And so I guess part of what makes that question so difficult to answer is because people don't fully understand the implications. Um, do you have anything you can share on in terms of what the implications of that decisions are, so that people can be fully informed?
Yeah, so I always think it's quite helpful to have an example of a situation. So obviously we've done many of these. We primarily specialise in international work. And so this is one of the most common questions that we're up against. And they're often time sensitive as well. But for example, just to sort of set out sort of diversity of laws between countries, commonly, England is fairly generous compared to the rest of the world, and for some time it had the reputation, and still does to an extent, of being the divorce capital of the world. And you may have read about people forum shopping to come here to get divorced, and because it helped the weaker financial party more than many other countries. So if I take a sort of French and English example, quite commonly in France, and in most of Europe, you elect a property regime when you marry. Now, if you're French and you're used to all of that, you may think, well, of course you do, that's what we do when we get married. But if you're from England and you're marrying somebody in France, that is a completely alien concept. But you're still choosing, often the day before the wedding, at a notary's office, whether you're going to elect for separation of assets, community of property, or a mixture of both. And that is actually a very important decision. And in Italy, it's literally a tick box on the marriage application to say which one you want. So it's something that has fundamental consequences, which people don't always understand is so significant. And a notary will explain it and explain the differences. But the English person, for example, might not understand that that precludes them, or is attempting to preclude them having the rights that they would have if they were marrying without that regime. And that could be very different in France and England. So for many couples, they quite like to be able to decide how they divide assets. And if you're from a family with lots of debts, for example, you may not mind if the option of separation of assets is taken. But for most people, and when we're talking about where the best place is, I'm assuming here that we're acting for the weaker financial party. If we were acting for the weaker financial party and they elected separation of assets, then the scope of them getting what England would deem a fair deal is very limited, because separation of assets means what it says, really. So basically, you keep what you have before you come into the relationship. And of course, if you've got a stronger financial party, they're going to have more than the other one. And then whatever you accumulate, you keep. So with a scenario which unfortunately is still common, where one person works, one person looks after the children, even for, even if it's just for a definitive period of time, their career path is going to be impacted. And therefore the weaker financial party, who is commonly the one that's elected to stay at home because they're not earning as much and therefore they're not losing as much by not going to work, cannot really save anything during the marriage. And therefore, I had a scenario recently, this was actually Italian rather than French, but it's a similar principle, where the lady in question would have got about £30,000 at the end of a 20-year marriage with a child. And we got her almost half of all the assets, because, and there's a whole reason behind that, which is probably another topic altogether, but in England, prenuptial agreements, or which in a sense a marital regime is, are not automatically upheld and they're not binding. So England has a concept of looking at sharing marital assets, but also needs. And financial needs can be based on the standard of living enjoyed during the relationship, and therefore it looks to see what the weaker financial party actually needs to move on with their life. And that might not just be basic needs. And if the agreement that they entered into in another country was perhaps done at last minute, without full knowledge, without full disclosure of assets, without information about everything that they needed to know, and possibly even without advice from England if they have an English connection,
Yeah.
then all of that can be undone by the English courts, and they can say, okay, you've got that agreement, we're taking it into account, but we don't think it's good enough. We're going to move away from that. And if you're acting for the wealthy party, that's a really big shock to them, and they have a real difficulty in getting their head around why, when they had an agreement at the time, that's not going to be upheld in England. If you're acting for a weaker financial party, it offers a lifeline, basically. And it's not about getting huge sums, it's actually about just getting what we deem to be fair. So that's one of the sort of examples of where it can make a difference. Another example might be for things like pensions. Or foreign assets. Many countries don't share pensions. And don't make orders about them. Other countries won't make any orders against foreign assets. And of course, there are problems with enforcement with foreign assets. But it can be something that's quite important in a case. And again, England can do that in a way that another country can't. And commonly for an English pension, which can be the second largest, if not the largest asset in the case, particularly if you've had a city worker working in London for a while and then they've moved back out of the country, then you need a local pension sharing order. So that would be another reason to say, well, let's look at England and see if that's a viable option for us. It's not always, but obviously that's the most important step to take.
But it's not just deciding which country is going to hear your case, it's also the laws of that country that are then going to be applied. They can be quite different from one country to the other. So I totally agree that speaking to a lawyer is going to be very important in gathering that information.
Of course, in Europe, and you'll know this from the number of cases that you have worked with too, in Europe they apply different countries' laws to different parts of the case, and which to English people is completely alien again. Even English lawyers it's completely alien to, but the idea is that it's often based on where you first lived when you were married, not always, and you need advice about it, but it can then mean that you might secure France thinking that's your best jurisdiction, only to find that English law is applied. Now it might not be applied quite like the English lawyers do, and it's better to do it in England if it's going to happen under English law, but you know that can be another surprise to people when they're contemplating where to divorce. So I had a scenario the other day with somebody who is thinking of issuing in another European country, and the lawyer is checking because they've had a very complex way of moving around the world since they've been together. The lawyer is having to check very carefully which country's laws would apply to their situation. And if it transpires that the local law in that particular European country isn't going to apply, then we'll do it in England. But otherwise, it's better to do it there. So it's, you know, it is really complicated, very interesting, but also requires an awful lot of input from specialist family lawyers. There's no point just going to your local lawyer for this sort of information.
I totally agree. And so clearly the nature of the laws and how advantageous they might be to your specific situation is a big consideration. Is there anything else that people need to think about when choosing jurisdiction? Anything else to consider?
Absolutely. So although you may be able to bring proceedings in one country, it is important that you have a sufficient connection with it. So if there's an obvious place where you've spent most of your married life and you've been there years with the family, then even if you issued in another country, you may find that you are that jurisdiction is challenged, because it may be determined that actually the other country is better connected and better suited to dealing with it. The exception to that again affects European countries, of which England was one, but isn't any longer. And this is a particularly important point if you are in a situation where you are considering a European country and an outside European country, because the first in time to issue principle still applies. And in that scenario, you might have lived in one country for many years, but you had enough connection with a country in Europe. You start proceedings there and issue and take steps to serve immediately, and that will just secure the jurisdiction and there is nothing the other European country can do. Now, with England and the rest of the world, it's typically where you have the greatest connection, which some feel is a fairer way of dealing with it, but in other ways it's less clear-cut, so it can lead to further litigation. And the decision of whether to litigate if you have got left with the wrong country is always very difficult, because it's an expensive process before you even start the divorce proceedings and the financial arrangements, because often when that happens the proceedings are stayed, and the country both have to stop the divorce and financial proceedings to determine this issue, and that can take a long time, and it can be very advantageous to one party for it to take a long time. So they are big decisions, but thankfully not too many are contested, simply because it's a lot of money, and for most people the proportionate value of arguing about jurisdiction and the outcomes is not sufficient. But it does happen.
And I think in choosing the jurisdiction, I also usually recommend to my clients to think about other factors beyond the law itself, in terms of the cost of divorce, which is not the same in every country. Do they have no fault divorce in both jurisdiction, or do you have to blame one of the spouses for the breakdown of the marriage?
Well, also in terms of the conduct side of things, sometimes it has bearing on what financial relief you can get. Yes. So, still in some countries, if there is an element of adultery, for example, or abuse, then that can actually equate to a reduced claim in that country. England has never been of that standing, but we are pleased to say that we are at least no fault divorce now, which means we don't have to have some horrible list of reasons why you think the other person was responsible for breaking down the marriage, which was never a good start to any divorce.
Absolutely.
But we also have to take into account things like language differences. Are you going to be comfortable with the court system in that country? Do you trust it? Unfortunately, some court systems aren't as reliable or haven't got as good a reputation as, say, England. I know bribery is quite common, that sort of thing. That's obviously not too many countries are like that. Most are fine, but there are some. And also the level of disclosure you're going to get. You may find that you would get far more financial disclosure in England than you might in other countries. We're very robust about our disclosure. In Europe, you don't have an obligation to tell the other side everything you know about your client's finances. In England, you do. So if you tell a solicitor something, then they will have to disclose that information about the finances. We can also look behind trusts. We can look behind company structures. We can look at strange transfers that have just happened before they've announced they're divorcing, and to see whether or not those should be undone or deemed to be undone. We can make adverse inferences about people's wealth if they don't seem to be telling the whole truth, but we just can't find the answer. So there's lots of scope in England for a much more detailed investigation. Other countries, may have similar levels of disclosure, but commonly they don't. And again, that can be a disheartening thing.
Yes, for sure.
If you've got somebody, coming from a country where they wouldn't have to disclose very much, and being told that in England they've got to show everything, including the family's trusts and all sorts of things that they perhaps thought would never come into play. Because in England, we don't have such strict categorisation of the assets we can use. So, for example, if needs can't be met just from the marital assets, our courts can dip into premarital or inherited assets or gifts, which again is a big surprise to many and very contrary to most other countries. But it's this principle of needs that sort of sets us apart. And I think the other thing that people don't often remember with the UK is that parts of the UK are also very different. So the laws in Scotland are more akin to Europe. And there is a huge disparity in what you would get in a Scottish case than an English case. And again, they don't have that principle of needs. So there's so many factors that you wouldn't have even contemplated probably, that just mean that if you've got two countries involved, or you've got connections with more than one country, I mean, it can be 5 or 6 countries sometimes. then you must get advice quickly, and do not speak to your spouse about it. And I would also say be very, very cautious about who you talk about it to at all, and instead go and see a lawyer, even if you never split up. You know your rights, you know what to expect if it happens, and they're never going to have to know if you don't want them to.
Yeah.
Confidential, but you've got information and you are forewarned, therefore armed for the future. And I think more people are doing that now as a protective stance, and it is sensible. Because sometimes it's something you have to do very quickly. That's the other sad thing, particularly about the first in time rule. You were finding that people come to you thinking they probably are at the end of their marriage. It's never an easy decision, and yet having to make that decision perhaps faster and without telling their spouse. And it's all very difficult.
Never helpful.
Very difficult. So yeah, it's a very big step to take. Other factors, I'm just thinking in terms of what you might want to consider in addition to the actual legal boundaries and prospects, might be things like timing. So if it's much quicker to get divorced in one country than another, that might also be something that's very important to you. Some countries are incredibly slow, and that can have a big bearing. It can also mean that if you start proceedings first, regardless of whether there's a chance they could challenge based on choice of jurisdiction, you may be further along in the divorce proceedings in the first country, and the other person might think, oh, A, we can get it done sooner there, or B, I can't be bothered now that they've started already. So it's still better to try and get in first and select your jurisdiction before the other party does so. I mean, for some people, it doesn't make any difference. You know, we're only talking about it really where there are significant disparities in outcomes and finances. You know, otherwise, it may not matter, but at least you have a lawyer to say, I wouldn't bother, rather than doing that yourself and finding you've chosen the wrong one and then trying to have to undo it because the other person will immediately jump on the one that you may have inadvertently agreed to do. So it is very, very important to get that right at the beginning.
I agree. And I think also, you know, that's where the person's priorities are going to come in, because there's so many things to take into consideration. If their top priority is to get, you know, their French prenup, you know, their contrat de mariage in force, then that's going to, you know, dictate which jurisdiction they choose. If their priority is doing it on the cheap, it's going to be probably a different choice. If it's, you know, how fast they can get divorced. So setting those goals in terms of what they really want to get out of their divorce is going to be really important in making that decision.
I think other factors besides the you know, whether you're going to win or lose in a particular jurisdiction, they can be incredibly helpful for negotiation purposes, because if you have secured the best jurisdiction, it doesn't mean you have to fight tooth and nail to get the absolute maximum, but it means that the other person knows that that law is going to be the guiding law for settlement, and therefore the chances are they will settle for a higher level than they would in the other country. And that can be a good means of just getting it sorted out quite effectively and more fairly. Other times, let's try and think of any other scenarios which clients might contemplate. Well, I guess, you know, it's quite an aggressive stance to decide which jurisdiction you want. And therefore, another factor is, of course, what bearing is this going to have on the family, and that could be bearing is that going to have on your ability to leave the country, for example, with the children, because you probably all know that you can't move away from the country that you're living in if you've got children without the other parent's consent or a court order. So sometimes, rightly or wrongly, the financial side can also be used as a negotiation in terms of resolving the perhaps bigger issue of where the children actually reside. Because, for example, if the stronger financial party doesn't want England, and they wouldn't probably want England as a jurisdiction for divorce and finance, and the other party wants to move, then the other party might say, okay, well, I won't go for as much as I could in England if you let me move. And that might also be connected to the fact that if they can move, they can live more reasonably financially too. So the two things shouldn't be connected, but invariably and inevitably they can be. So that's another big.
It's a really good point.
Yeah.
Well, that's all really helpful. Thank you so much, Lucy. But I like to end my podcast by asking my guests for their top 3 tips. So in your case, if you were somebody, if you were meeting somebody who was making a decision around jurisdiction and they were the one getting that choice or that option, the ones deciding, what would be your top 3 tips to them in terms of making that decision?
Right. Firstly, if you are sensing that the marriage is in difficulties, even if you don't know if it's going to end, go and speak to at least a local lawyer, preferably a lawyer in each of the countries that you have a connection with, just to see if you can divorce in those countries, how long you have to wait to do so, if there is a timeline for that, and what the other person can do, importantly.
Yeah.
Because you might not be ready, but they might be. And so this is always the danger of sitting back and not doing anything. You may learn the hard way that you're served with proceedings from the other side, the other person, the other spouse, before you're ready yourself. Secondly, don't talk to anybody about it except a lawyer. If you have to talk to friends and family, be very, very careful. You never know when things might slip out inadvertently. And also everybody's situation is different, and the stories that they have and the laws they may be relying on may be out of date. So it is dangerous to look on the internet alone or just ask friends for their experiences of divorce, because every case is different, and in England in particular, every case is different. And I suppose thirdly, just get yourself sorted out a little bit, in the sense that practically know where the marriage certificate is, have some funds of your own in your own account, because if you're taking advice from a lawyer, you don't want your spouse to see on the credit card or the current account that you're paying the International Family Law Group money, because it's quite an obvious name. And indeed, most lawyers can be looked up very quickly. And if you're independent on a visa, perhaps start thinking about, can I get visa in my own status, because that can cause terrible problems. One of the saddest problems can be in countries where you are a dependent and the children can stay, but you can't.
Yeah.
And it can be used, and it's a very, very vicious and nasty tool. So the more independence you have, the more financial independence you have, the better you'll be placed to deal with things, per se. That's not always possible, I know, but if you can. Yeah, I think, but the main one is don't talk to your spouse about it until you've decided, because they can do exactly what you're doing and still manage.
Yeah, and there's so much at stake based on which jurisdiction gets selected. So you do want to ideally maintain that control and that decision.
You do, yeah. And then once you've secured it, you can be nicer. We can start to mediate and talk, and you can blame a lawyer, and we can stand in front and say, well, we told them to do it, and all of those things. But it puts you in a much stronger bargaining position, even if you ultimately decide not to, take the harshest course of action. You've got control, and as you say, that's the important part in all of this.
It's a whole preparation piece, really, in terms of gathering the information you need to make that decision.
And certainly with England, for example, you must be careful about gathering information from your spouse. We mustn't be given any documentation that belongs to your spouse. You can really only give your lawyer in England. It may not be the same everywhere, but in England, you really can't give your lawyer anything that you haven't been voluntarily given by your spouse, or you can get into trouble, and we can get into trouble too. So that's another thing to bear in mind, but it doesn't hurt to keep informed about what the general financial position is, keeping a record of what sort of bank accounts and where they're held, and with which banks things are held, because that always aids disclosure. If we know something hasn't been shown to us, then if you can remember that there was an old Barclays account in wherever, then we can ask about that particular account. Absolutely. Disclosure. So those sorts of things, just being prepared, really. And I do strongly also recommend, a protective meeting if you are in any doubt, or if you're moving country, because you're your rights will change considerably, and there's no
Yeah.
harm in having an hour or two's conversation with somebody and being aware of the things to consider, because often forward planning is helpful in
Absolutely.
formulating where you deal with matters.
Agreed. Those are all great tips. Thank you so much, Lucy. It's
Okay,
been
it's
great
lovely to
having
see
this
you.
conversation.
That's fine. Okay, good.
Thanks so much. Have a wonderful day.
And you. Okay.
Take care.
Bye-bye.
Bye.